training. We have one more training coming up, and that is May 25th. It's our wrap up, and Family Voices will be here to present their presentation called What is After High School. So we really look forward to seeing everyone there. We've really enjoyed providing these trainings for everyone, and we've all learned a ton too. Tonight, we have George Zaske is joining us. He is a parent using supported decision-making, an attorney, a member of a statewide group promoting supported decision-making and disability advocacy. All right, George.
Okay, so I'm going to see if I can share my screen here. This is going to stop you from your screen if I hit continue.
Yep. Sounds good.
Go ahead and boot her off, George.
Yep.
Yep.
All right.
Yes.
And make this. All right. So, okay, it should be. There we go. As was mentioned, my name's George Zaske, and this is a presentation on supported decision-making. I interweave my experience with supported decision-making as a parent, some of the things I've heard over the last couple of years of other people using it, some experiences with guardianship to do some comparing and contrasting between supported decision-making and guardianship. As was mentioned, I do have an adult son. The stories that I share, I have his pre-approval to share. I think when I first started doing this many years ago, there was a tendency to overshare. I think sometimes parents can do that because they're trying to get help. They're trying to get their story across. They're trying to help people understand their circumstances, but this is my son's life. And so if I'm going to share information about him, I usually ask his permission and give him the range of stories. I have a kind of a set that I use, so I can talk a little bit about that. I am an attorney. I'm licensed in both Minnesota and Wisconsin. I do guardianship in both states. So Minnesota has a few differences than Wisconsin. Recently, they passed a law that for anyone under the age of 30, they have what's called a time-limited guardianship, which is something I'd like to see here in Wisconsin, where you can only put a guardianship on for, I think it's 72 months, and then you come back into court and revisit it. So I think that's a really good idea. I know our group has been looking at that because you put a guardianship on somebody at 17 and a half, if you never revisit it, they could be under that guardianship for decades, 40, 50, 60 years. I'm also a board member of a service provider up here in Western Wisconsin called Bridge for Community Life. So I have some experience with agency that provides day services, some respite and recreational activities. And we've been scrambling like so many others with the pandemic on how to provide services. So it's been quite a learning experience for us as well. Little disclaimer, because I am an attorney and I don't want anybody construing what I'm giving as legal advice. I don't particularly know your individual situation, which can really have a great impact on what I would share with somebody, but what I'm here is to educate and to provoke some discussion. And certainly if you ask me questions about, and you give me broad facts about your situation, I can certainly give you high level education, but not something that I would, necessarily put before a judge. Sometimes we'll do an audience survey to get a sense, but I did check the chat, so I was able to get a sense of, there's a number of parents here. There are some people who are supporters in terms of counselors. So it looks like we have a nice variety of folks. And so we'll get right into this. One of the deals that I have when I give presentations is I do a short PSA, and my PSA is for ABLE accounts. If you are a parent who does not have an ABLE account for your child with a disability, I encourage you very much to look into it. It can be a great way to save money up, to have other people contribute money. This website is an awesome resource, the ABLE National Resource Center.org. If you go there, it can give you all the information that you need to answer questions about ABLE, as well as do comparisons between different ABLE accounts. We are allowed in Wisconsin to have an ABLE account, a beneficiary. Your loved one with a disability can have an ABLE account. We just don't have a ABLE account plan in the state of Wisconsin. So you need to pick one from Minnesota or Ohio or California, and then open an account. It takes 15, 20 minutes. And then when your child gets transition age, you don't really have to worry about that. Oh, I'm going to hit the $2,000 limit, which puts my benefits at risk. You can just transfer money electronically. It's all electronic banking over into the ABLE account and keep yourself safe in terms of benefits. So I was in a CLE a couple of weeks ago, and ABLE account has been around for about since 2015, and about 8 million people could utilize an ABLE account that qualify, they figure, and the number of ABLE accounts that are open nationwide is under 100,000. So it's really not very well utilized, and I'm trying to encourage more and more folks to use that. When I do estate planning for people, I often ask if they have one. If they don't, I recommend they open one. They don't need an attorney to open one. It's very similar to opening a bank account. So that's my PSA. I often start with asking people if they are familiar with Seinfeld and the episode where they had long talkers and, fast talkers and slow talkers. Well, on this topic, I can be a long talker. So I was informed that this is only supposed to go for about an hour. Leave time for questions. So I'll try to keep that in the back of my mind in terms of being respectful of people's time. While there is no singular definition of supported decision-making, this is the one that's been out there and utilized by most people for a period of time here. It occurs when people with a disability use either a friend, a family member, or other professionals to help them understand and come to a decision where they make the decision. They are the ones who maintain control, and they're the ones who ultimately make the decision. The person who's there with them helps them with processing information, with getting information, and they are the ones that will support that person to make the decision. With guardianship, that has been around for a very long time, going back to medieval times. Even before that, even in ancient Rome, there had guardianships and wards, guardians and wards. That is a substitute decision maker. And if you become a guardian of someone, you are substituting your decision making, your judgment for theirs. And what's the current state? Well, the world is changing. And I've been doing advocacy for some time and I'm standing on the shoulders of people who were before me and hopefully building on their work. But we had near the turn of the century, the Olmstead decision, which was getting people out of institutions and doing living and working in the community. We have person-centered planning. We have ABLE accounts. We have Project Search. People who transition out of high school can go into a Project Search program to be able to learn job skills. You have Think College, which is post-secondary education. When my son was first diagnosed, A number of these things on this list did not even exist. And now they are, and more things keep coming online. And I would say that that's just an indication of our world is always going to be changing. So you're going to want to stay aware, and you're going to want to position yourself, in my estimation, so that you can maximize opportunities for your loved one. For example, think college, there are certain programs around the country that your child can get a post-secondary education, but some schools will not allow someone under guardianship to participate in their program, for example, because there's a concern about when the decision-making could happen. So you may want to, factor that in if your child has an interest in going to post-secondary education. And one of the things about some of these programs is they can be quite expensive. Across the river in Minnesota, there's a college called Bethel that has a program called the Build program, which your loved one is on campus. They have supports, and they learn social skills, they learn job skills. I know a couple of families who've had their loved one go through it, and it was an awesome experience. But that program costs $30,000. So able accounts didn't exist 20 years ago. If they did, I might have opened one up, but and because they are modeled after the 529 for paying for education for parents. So that's just an example how some of these things can be interrelated, and to keep an open mind and always keep an eye on the horizon. Now, my son has a rare form of epilepsy, so that has, focused my attention on the brain, neuroscience, and brain development. And what research has shown, as well as MRIs, functional magnetic resonance imaging, that the brain, the human brain, is not fully developed until around age 25. So that is true whether you have a intellectual disability or not. I like to tell the story when I dropped out of college at 19. That was a decision I made. Both of my parents did not think that was the best decision I had ever made in my life. And I won't ask anybody if they've made similar decisions, but it would not surprise me if you had a room of 100 people, more than 2 or 3, if they were honest, would raise their hand about some of the decision making they made at age 19 and 20. If you talk to my sisters, they would probably still argue I don't make such great decisions. But with the physical development, it's opportunities to learn and grow. And what happens is that there's increased connectivity. There are the trimming, the pruning of neural pathways that are not necessarily helpful. There is a moderating of impulse behavior and an increase in executive functioning. But all of that comes along with practice. And studies have shown with guardianship that that can be interrupted or stunted to a significant degree if someone knows at some level that they aren't making any decisions, that they are not, in a sense, their own person. A couple of years ago, I sat on a panel with a neuroscientist from the University of Madison, and she had pictures and in fact showed some of the differences in the brain as it develops over time. And so this is backed up by clinical science. As I said, the development in the prefrontal cortex continues. It's where you have attention, your focus, more complex planning, decision-making, logical thinking, organized thinking. Your personality can continue to develop. My son at 17 and a half, when he would have been eligible for a guardianship, is the way he behaves and carries himself and what his goals are significantly different back then when they are now. I mean, back then he would have been more than happy to spend his days playing video games. And just recently he picked up additional hours working in the community at his job, which is something that he wanted to do. So in that 4 or 5 years there since he turned a legal adult, there has been a significant amount of maturation, so that what he's doing now, I think if we'd have just put a guardianship on him at 17 and a half and tried to make decisions for him on a regular basis, I don't think he would have had the development that he has had, nor do I think we would have been as parents as accountable to making sure that he had opportunities to make decisions, opportunities to take some risks, and to have some failures, have himself come up short or make some bad decisions, but none that were, devastating in that regard. So these are the kinds of things that promote healthy brain development, cognitive challenges, in an environment that's very rich, and socialization, education. And that's why some of these things like Project Search, Think College, I have over my years come across teachers who have lamented how young people that they helped educate went off and basically disappeared on the sofa in their parents' home, because there weren't as many opportunities. I think our thinking wasn't as sophisticated as it is now about what happens, and I think the focus was on protection. And there are different ways to protect individuals, and research has also shown that the more autonomy someone has and develops, the more they're able to self-protect. I mean, I can remember times when going through therapy back, we were always looking for my son to be compliant with the therapist because we wanted to maximize the therapy session. We didn't want a lot of disruptive behaviors because we would lose that precious time in an hour-long therapy session. So in some respects, when our children are younger, we want them to be compliant so that they can maximize their educational and therapeutic opportunities. But when they get older and they have more opportunities to be on their own or have other people engage with them, to have them understand that they are an independent person, that they can make decisions for themselves, and that they can say no, and they don't have to always be compliant. And as we understand that and develop and give them opportunities in that 17 and a half, 18, 19, 20, 21 time frame, that can very much help them get a better sense of who they are and their sense of self. A guardianship starts with a petition, and our system is now set up so it's rather easy to fill out a guardianship petition. It's about 7 pages long. It's a form that's available online. I know that many parents will do it without an attorney. It's something that can be done. It also, I think, if not given a lot of in-depth thought, if the focus is trying to just get a guardianship so that you can protect your child, which is very laudable and understandable and may be appropriate. I'm not saying a guardianship isn't appropriate in certain circumstances, in maybe even a larger number of circumstances. But I would say, from what I've seen with my work at Bridge for Life, if I've heard it one time, I've heard it a score of times, where a worker will say, Margaret could do so much more if only her guardian would let them. So there is, and not many people want to go up against, a parent and point out that maybe they're being too restrictive. But I know of cases where it's been pushed back and parents have been removed as guardians. It's pretty rare, but removed because they just didn't exercise their power and authority appropriately. But a parent can do this without the use of an attorney, and the forms are available online. And this is kind of an example of it. And just kind of paging through it. A number of years ago, 7 pages. A number of years ago, I gave a presentation and I filled one out sort of on the screen. I had an overhead projector and I had somebody time it. And I'm experienced, so obviously I could go a little faster, but I filled out this form in about 5 minutes. So basically I filled out a form that could be used in a court that, if approved, would take away somebody's rights pretty much completely. And I could do that within, 5 minutes worth of check boxes and the like. And when I have been doing these talks and continue to try to give information about the lay of the land and the way things are, this is the most recent study I could find, because, guardianship is not a big thing in local courts. It's in the probate division, but the study found that most guardianship hearings, lasted less than 15 minutes. Now, I practice in family law and I do motion practice. And when I go in, the court, addresses the attorneys, they ask for appearances. I was stunned when I saw this number. I understand why, because oftentimes it's in the guardianship of a minor transitioning to an adult. It's the parents that are coming in. It's the parents who know the child best. It's the parents who want their child to be safe and they believe a guardianship is appropriate. But you certainly don't get a lot of in-depth discussion as to whether or not a guardianship is appropriate or it's the least restrictive approach that someone can take in 15 minutes. Here's some more information about guardianship. Studies show that only 25 or 50% of families with a child with a developmental disability, adult child, make concrete plans for that child's future. And I know this from my work as in the estate planning arena. I have worked with families and they will, they'll fill out the paperwork. They'll only get so far and then I may not hear from them for years, quite literally. I've given them my form to fill out and it'll be a couple years before they get back to me. I know life happens. Planning for one's demise is not a happy time, but we need to have plans in place. And the more you need to identify who's going to be a successor guardian, because it's very likely that somebody else is going to take over that guardianship order in the future. It might be a sibling, it might be a cousin, it might be a professional guardian. It may be hard to determine. But it's also true that most adults with developmental disabilities live with their parents well into the adult child's middle age. It's an amalgam story, but I gave a presentation and afterwards an EMT came up to me and relayed a story about how they went out on a call in rural Wisconsin here with a 70-some-year-old female. It was the mother, was having heart trouble. And they wanted to put her on a gurney and take her to the local hospital to get her checked out, but she wasn't terribly cooperative because on the sofa was this wide-eyed 40-something man who had an intellectual disability, seeing his mom get ready to be transported, and there was nobody else in the house. So they ended up having to call the sheriff's department to get a deputy to watch over this young man while they transported mom to the hospital. And then unfortunately, because there wasn't a plan in place, adult protection had to be called in the short term to be able to take control of this individual so that they were safe. And it's been described that guardianship is sort of a part and parcel of what happens at 17 and a half. And I know this from personal experience. You get 17 and a half, you're in one of your final IEPs, and then the questions come. Are you going to continue going to school under the IEDA for extended education up to age 21? Are you going to apply for long-term care services? Are you going to apply for SSI? Are you going to need guardianship? And all of this tends to hit right at that particular point in time, and it can be overwhelming. And I know that there are myths out there that, well, if you have guardianship, that's a given that you will qualify for long-term care benefits, and that's not necessarily the case. And a guardianship, really implicates and restricts a person's constitutional rights, things that you and I take for granted every day, who we associate with, medical decisions, how we spend our money, whether we have a job or not. All of those things are basically taken away or can be taken away under a guardianship. And it's, a court-ordered loss of personal freedom. Some people have referred to it as civil death, and commentators have said that a prisoner in prison has more rights than someone under a full guardianship. This is the actual guardianship statute, and we know I'm involved in a group, and now we're trying to get the law changed, requiring that anybody who's going to apply to be a guardian has to go through some training. Right now, there's no training requirement. And what I like to highlight in this statute, and I, got this approach from a lawyer that I know down with Disability Rights Wisconsin by the name of Mitch Hagopian. And basically it says a guardian has to make a diligent effort to identify, honor an individual's preferences. In making a decision to act to the contrary of the person's express wishes, they need to take into account that individual's understanding and their skills, and they need to appreciate and involve that person. And whatever you do, it should be to the least restrictive option available. And so rather than a guardianship, what are some of the alternatives that people may have heard about? One of the things you can do is you can appoint, for some people call it a conservator, some people call it a guardian of the estate. It's technically in Wisconsin, guardian of the state. But there you control the money. And if you control the money, I mean, as a practical matter, tough to, pay for an apartment or move out if you don't have access to the funds. So that could be a less dramatic way of helping and having some influence in how somebody is transitioning from into the age of majority. And there doesn't necessarily get to be a declaration of incompetence, which is what happens in guardianship, is you are declared incompetent. You can go for a durable power of attorney for finances and property. That's something that people will do for their elderly parents. And it's been around for a very long time. But the thing to remember with a durable power of attorney, it is, in fact, substitution of decision-making. If I'm the power of attorney for my mom and she's checked the boxes, I can go into her bank account and take money out of it. If she's checked the boxes and trusts me, I can sell her home. So there's a lot of power implicit in the durable power of attorney, and I can substitute my decision making for that. There's a power of attorney for healthcare. That kicks in when somebody goes into the hospital and maybe they are receiving some powerful medication that impacts their ability to listen to the doctor's instructions or be able to make an informed decision about treatment choice. But that power of attorney for healthcare is something that kicks in when that person lacks capacity in a temporary basis to be able to make healthcare decisions. So it operates differently than a durable power of attorney for finance. Customized releases, either draft, you can get custom releases from the various bureaucracies or systems or agencies that you're going to come in contact with your loved one. For example, the clinic, the health clinic, the dentist, the financial institution. You can even get releases from the school so that you can get information, and your loved one would need to fill that out and sign it. And that could be a way of getting information and being around and participating with those various systems with your loved one with a disability. The other one that I think hopefully
George, can I interrupt just for a second?
Yep.
With the custom, what you just talked about?
Yep. Releases. Yep.
Custom releases. Will those also work, do you know, for institutes of higher education? Because I know we have a lot of parents in transition that worry that if their child goes off to college, they're never going to get any information from the college.
Well, again, if you're 18, you're your own person, and you would have to sign off on that. And I would say that you'd want to check with the college to see if they have a release that that your loved one could sign if they went off to school. But again, if they're not under guardianship and you're supporting them using supported decision making or power of attorney, then you're going to want to get that release and then get it signed and put in the file, and they can tear that up. They can let it lapse. I recently had to, with the clinic, had to update a release around my son's going in for a vaccination for COVID. So again, you'd want to check, and that's part of what we're trying to do with supported decision making, guardianship training, is to go out there and to make systems aware that there aren't just one or two ways. There are multiple ways to address some of these situations and to get them comfortable. Because I know when I was just going forward, the supported decision making law wasn't in place, and I mentioned it when I wanted to open an ABLE account, and said I was supporting my son to open an ABLE account, and we ran into some real challenges because they had never heard of it, and they wanted a power of attorney on file. And it's like, technically, I know as an attorney, you can't require a power of attorney on file, but people made an assumption if my son's opening an ABLE account, by definition, he has a disability, but it could have been a physical disability. It could have been a disability that's more limited, such that he wasn't under guardianship. I made that clear from the beginning, but fighting some of these big systems can be a challenge, and so sometimes it's better just to kind of go along. I see a hand.
Teresa Yep. So Teresa,
with a raised hand. Sure.
Teresa, if you want to go ahead, and if anybody else has any questions, please put them in the chat. I am watching that as well, but we also encourage you to raise your hands. So Teresa.
So I love the idea of the custom releases.
Yep.
Because for all the things you said. So love that. So, but one of my questions is, so my son will be 17 and a half, I think actually right now, or I think it's actually today. I got to know from his case manager.
Do the math in your head. Come on, you can do it.
So so we have actually been talking to him about how we're gonna manage the transitions and how that's gonna go. And we've actually started talking to him about if something were to how we would do decision making together and what he wants to put in place, and that what if something ever what if and when something happens to my husband or me, and then that there would be like another person to help him with decision making, if that would be like soon. So could we in those custom, what do you think as an attorney in those, I know you can't give me specific legal advice, but could we in a custom form put that there would be like a secondary, or would we have to start the process, or how does that, do you follow my line of thinking?
Again, what I would say is with the release, it's like, depending on the organization, they have different forms. And I as an attorney, I had some more leeway because I could actually draft my own custom releases. But you can approach the entities and ask them, because I've had that too, where I have a custom release that I drafted. I know it's perfectly valid, but for whatever reason, people like it on their own form. That's what their lawyers tell them. So you run into that. But you could again look at the release, and it says people who can have access to information. Sometimes there's more than one slot. So I would say, I can have information, his adult sister can have information, and his father can have information. I mean, there's no restriction on the number of people who your son could assign to say get information. It's just, you want to be careful of, you don't want tons of them out there. And I keep track. I have a spreadsheet. It's like, okay, we have one with the clinic, we have one with the dentist, we have one with the credit union, so that we know where they are. We had one with the high school, so that because some have automatic time limits on them, because you don't want them necessarily just to be open-ended forever. Some of them have, they expire after a year. I know when I do my work with clients, they give me permission to get information, but I don't want it once their case is over. So I usually let them, they can expire. But I would look at that in the form. It's usually 1 or 2 pages, and it just says who can get access to the information, and your loved one signs it and dates it. Make a copy, and so you have one, and then the original's put in that organization's file.
Okay.
And
so,
George, sorry, go ahead, Teresa.
Oh, no, ahead. I'm sure I'll get the rest in this is this is like super helpful. It's the second or third guardianship and supported decision making.
Yes.
And again, this is, again, I've been at this for a while, and there's so much pressure on guardianship. I mean, we went partway down the guardianship path. I had thought, we'll just do supported decision making, but the closer we got to it, the more, doubt and anxiety and, quite honestly, fear crept in. Even as knowledgeable as I was about these various topics, we went partway down that path, and when we went through the physician's report, and the physician was going through the questions: will you ever drive? Do you need help with this? Do you need help with that? I mean, I just saw the impact of those questions on my son as we were going through that, and it was hard. And he got real silent because I'd filled out the petition, and we started on the process. But after seeing that impact about, kind of the spark going out of him as he was asking these questions and impacting his future, we decided not to go down that path. And so we changed to use supported decision making even before the law. But like I said, I had some advantages being an attorney. I could press, but that was a number of years ago, 2016, 2017. We're farther along. More people are doing different things. So hopefully we're getting more institutions to change and to understand, more systems to adapt. Yeah, Tim, you had a.
Yep. So I have a question in the chat. There's a family that's planning to go with supported decision making for their sons, but they also have questions about looking for an attorney. Should they be looking for an estate attorney, a family attorney? I mean, people are talking an attorney. Should they see a financial planner? Who can help with all this stuff?
Well, the supported decision making, it's not a form, and I'll get to the question. I'm going to work it in so we can keep moving forward. It's more of a mindset, and that's what before the law, that's what I had to use, is to take that approach. So you don't need an attorney to fill out. I mean, we designed and crafted the law and the form so that you don't need an attorney to fill it out. The power of attorney form is available online. You could download that. I mean, an attorney can give you information and talk about it. I know there are, I mean, the attorney response is going to be the spectrum, right? There are people who really get this. There are other people who don't even do this because they don't want to do it, learn another area of law where they may not get a lot of business for guardianship, so they don't bother with it. But I would say you want to go with estate planning attorneys. Ask the estate planning attorney how familiar they are with like special needs trust, supplemental needs trust, guardianship, because it's more of a niche even within estate planning. And I know I've taken documents that have been drafted by, I'm sure, a very good estate planning attorney, but found some things that could be problematic for the adult child with a disability if they got too much money, the way the language was written. Sometimes it's a will that's grandma and grandpa wrote, and they didn't tell their attorney that, yeah, they have 10 grandchildren, but 2 of them has a disability. And they just say in the language, it's more generic, that says split equally among my 10 grandchildren, X number of dollars. Well, that's not good for the 2 with a disability. So that can be one way. There's the Greater Wisconsin agency, or GWAR. I can never remember what it stands for.
Yeah.
They have the Guardianship Resource Center, so that's a place that you can go, and they have a handbook that's really nice that can help you start to define questions you may want to ask. And I get people calling me up and answer their questions. Most attorneys will give you some amount of time to just see if you're a good fit, but you need to do some research in that regard. But not every attorney, I would say, is well versed in this field, and some of it's by choice. I mean, they might be a personal injury attorney, or they might be, even if you're a divorce attorney, family law is part of my practice. That doesn't necessarily set me up to be well versed for guardianship and supported decision making. I think your best option is to go with an estate planning attorney and build out from there.
Thanks, George. We also have,
sure.
I've been putting some resources in the slots, which I'm sure you're going to come up to, but the question is about supported decision-making forms.
Yep.
And where can they find few source sets for the process to understand it a little bit better?
Yep.
So you've already answered some of that. So
yep.
continue going that way.
Yep. And it's coming.
Sounds good.
Supported decision-making is about, relationships, practices, arrangements. It can be more or less formal. It can have different levels of intensity. I keep saying I would love for somebody to step up and be willing to support my son to make a decision about his new gaming system he would get. I have been doing gaming systems for a very long time, be it a Wii, an Xbox, a Sony PlayStation, and they keep making changes. And, somebody else younger, more in tune, and that would be a great way for him to bond with somebody and say, okay, Mike, I'd like you to help. And you could have that discussion ahead of time. And then that person could help them decide what is the best gaming system for what they want to do. And so I use that as an example to show you can do a supported decision-making form on a very specific individualized decision that's very time boxed or time limited, and get practice doing it and identify, because I think it's also a way to identify other people that you can engage in your loved one's life that can help them in different arenas. You know, if you ask somebody to be a backup guardian or a successor guardian, that's a pretty big ask. If you want to ask somebody to help your loved one with a disability make some purchase decisions, that's a different kind of ask. And so this is some information about what supported decision making is. I stole this from a slide from Kate Schilling. She's an attorney with GWAR out of Madison. So that's something that I like to give credit to Kate. There's actually no single definition or model of self-determination. It has been around. Many states have supported decision making now. I think we're up to over 20 states. The gentleman who's best known for the concept of supported decision making and popularizing it and advocating for it is a gentleman by the name of Jonathan Martinez. He's listed here with blank. He came up to Wisconsin a number of years ago for a self-determination conference, and I basically went to every presentation that he gave, the keynote and then all his breakouts. Kind of followed him around like a puppy because I wanted to get as much information as I could about supported decision making. So if you were to do a search on Jonathan Martinez and supported decision making, you'd find a lot of information. And these are the values of supported decision making. Autonomy, self-direction, that's a big deal, deciding where you want to live, what you want to do. It helps with developing trust. It's also giving respect to the individual, that they are a person, that their ideas and what they want considered in decision making is respected. And I also stole this from Kate Schilling. And other concepts to consider is presumed competence. Under the law, you turn 18, you are presumed competent. Going for guardianship is you're making an overt, concrete effort to have a court decide based on the facts, circumstances, and evidence that the person before them is incompetent. And that is a determination. If you check the box that they can't vote because they're not competent to vote, then, you know, after the hearing, notice will go down to the Elections Commission and they will be put on a list that will say they are not competent to vote. And that's one that I think gets overused. I actually, a couple years ago, helped a family restore their loved one's right to vote. They probably never should have lost their right to vote, but their parents did it themselves. And they just kind of went through, and when their son found out that he couldn't vote, he was devastated, which then in turn really impacted his parents. But we were able to correct that. But I also have run across others where I know they have the capacity to vote. And that's the thing about guardianship. It's a hammer type response. There are different levels of competency. The level to decide who to vote for, you know, is not the same level of competency to sign a contract, or that isn't even the same level of competency to decide to give informed consent on a complex medical procedure that could have years of medical ramifications. So yeah, go ahead, Tim.
So another question in the chat box. Number one, I'll give you the one that I think you can answer quickly.
Sure.
Is there an option to start guardianship later if supported decision-making is not sufficient or not working out for some reason?
Oh, absolutely. Absolutely. I mean, I've said that. I don't know if a limited guardianship may be appropriate for my son.
And that's the other question while you say that was, can you describe a little bit more about what limited guardianship is?
Well, I'm not going to go click back to the form, but every one of those powers that you're asking to get to right to make medical decisions, you can remove that right completely, or there's another box that you can check and say, I want limited, their rights limited. And maybe it's, psychotropic drugs, and it's just in that arena. The other one that I usually use as an example is financial. Maybe they shouldn't be making financial decisions when the decision has 6 figures in it. So you could put, you could limit it and say any financial decision involving more than $10,000 or $5,000, the guardian needs to sign off on that. But anything below a certain amount, they can make that decision, and that can be a way. So that can be an example. And so but people just tend to check the first box, which is removal of the right, and then it goes to the guardian. So if you look at that form, you can see where you can have you limit, or you don't have to if a box isn't checked, then you don't lose that right. So if you don't check they lose their right to vote box, they retain the right to vote. So that's what I mean by limited. So you'd have to, it's paying close attention to that form. So hopefully that helps. And there's more states than this. This is an older form or older PowerPoint that I'm using.
When you get a chance, Teresa also has another question.
But there was a real life case that Jonathan Martinez was involved in back in 2013, and it was a contested guardianship between a daughter and a mother, and the daughter had Downs, and it got national attention, and turned out that, it turned out that, mom lost. The court sided with the daughter, and what they did is they put a guardianship on for a year, and with the goal of removal at the end of a year. So people had to work, as did the young woman, to make sure that they were well positioned and got themselves situated such that the guardianship could be removed in a year. And it was a tough case. It was a young woman who had done well on her own, but she got into an accident on her bike, and then she was forced to basically rehab at home, and mom got more and more concerned. And so she decided that the best way to protect her daughter was to get full guardianship, and that's not something that her daughter wanted. So it ended up being a contest in court. Here's some of the resources for you. There it is, Greater Wisconsin Agency on Aging Resources. That's that organization. They have a very nice, that's where the Guardianship Center is, which is a little bit confusing because if you're thinking about 17 or 18-year-old, you wouldn't think to go to the Aging Resource Center to find information on guardianships, but that's where that center resides. If you go to the Board for People with Developmental Disabilities, at that location, they have the supported decision-making packet, which gives it frequently asked questions. It also gives information about the form itself and how to fill it out. If you want more information more broadly, and the National Resource Center for Supported Decision-Making, that is that's the organization that Jonathan Martinez was involved in terms of trying to spread more information out about supported decision-making. There's a form about guardianship at the Department of Health Services at this one. Minnesota has a very nice YouTube series that actually showcases Jonathan Martinez talking about supported decision-making and guardianship. In fact, Minnesota requires that people view that as before they become a guardian. So yeah, questions?
Teresa put her hand down.
Okay.
But we also did have a question about, is there a specific guardianship form or petition form name or number? I've listed a few things that I know in the website in the chat box, but there doesn't, I don't think there's one form or where you can find that. I put a few things again in the chat box. Like I know you can find information on the Wisconsin court system, the law library, DHS. Do you have any place specific?
Yeah, I mean, if you do Wisconsin courts and go circuit court and you say something like guardianship forms, it'll bring you to the guardianship forms, and it's broken out. There's a packet with instructions that tells you what you need to do. It lists out the different forms that you need, the approach for giving notice, the fact that you need to have the physician's report done and into the court 96 hours before the guardianship hearing. So all those forms are there in terms of, having a guardian ad litem come and visit the individual and let them know that somebody's applied for guardianship, that they're going to be award, and let them know because they have a right to contest it if they want. So yeah, all those forms are available at the circuit court website, the state of Wisconsin. And the other thing you'll find is that sometimes different counties have their own local rules. I've run into that a few times. And as I said, it's in the probate division of the courthouse. So if you were to call the registrar and probate, they can't give legal advice, but they can also be a resource to help you. I know certainly the ones in the smaller counties I know from my personal experience, are very helpful in terms of, telling you the forms you need and what the process and procedure, but they won't tell you how to fill it out or give you any legal advice.
And there was a question about new state laws being enacted in Wisconsin. My understanding is the time limited guardianship is not in Wisconsin.
No,
it's only in Minnesota.
It's only in Minnesota. Our group, that we have a working group, and the first thing that we did was to get the supported decision-making law in place, which is Chapter 52. Now what we want to do is see about at least having guardians trained before they accept the responsibility. Because we know that there are people who they've never read their roles and responsibilities in the statute. And in some ways it's understandable, because some parents become guardians and they just continue with the parenting that they've been doing, and they're not taking a more refined look of it's not the same role. And that can be hard. I mean, I understand challenging parents, because they're the ones who've been raising this child, and resources and time and energy for a very long time, and people have come and gone, but they're the ones who've been the rock for forever. And who's to tell them that, they're not doing it right? Well, yeah, it's possible. And I don't mean that in a disrespectful way. I just mean you just can't, basically use the guardianship to continue parenting in the way you did a minor. It's not appropriate. But that can be sometimes hard to hear as a parent.
So then right now you're working on the law to get training, and then hopefully
so
down
guardianship
the road,
training.
we'll
And so
limited,
we've talked about
limited.
seeing about doing time limited, because it would be, it's helpful that a state close by has done it. Other states have done it as well. But one of the things about, time limited guardianship is you're back into the court system more than once. So, depending on your legislative makeup, that there's more costs, administrative costs involved. So with the guardianship training, there wasn't a whole lot of cost, and then it's like,
a lot easier to push through.
So we try to, those are some of the political realities that, we've looked at, but I would love for there to be a time limited guardianship. I think it's very appropriate.
So I'm going to ask you,
but get everybody on the same page is going to take some time.
Well, hopefully Minnesota will show how fantastic it is, and then we could just point to the west. They
don't have supported decision making. I've been over there.
That's right. Yeah. So
they don't have. I've been over there talking to them about getting supported decision making. But when they told me they had time limited, I said, focus on that first, and then come and talk to me, and we'll see about getting you supported decision making.
So last question before we're going to make a formal goodbye, and then we'll hang on if we can for just a little while. But so a question that I don't understand, which hopefully Signe repeat in words that I understand. So I'm going to read you the first
Sure.
the first part that is beyond me. Is the work group working on conversion from 51 to 54/55 timelines? And then the next question under that, which may be a clarification, any discussion to allowing emergency protective placements to geriatric psychiatric wards?
We didn't change, we didn't impact any of the supported decision-making did not impact any
okay.
of the other chapters, whether it's an emergency placement, whether it's a temporary guardianship, none of that was touched. Those laws were touched in such a way that under the guardianship law, it made reference to, did you consider supported decision-making before you decided to go with guardianship? Because supported decision-making is a least restrictive approach to assisting somebody with a disability. And Kate actually tells a story that she was in court when the law first came into being, and the judge from the bench, the law just passed, and asked the attorney and the family, did you consider supported decision-making? We have this new law. And they hadn't. So he said, well, why not? And it's like, there was a pause. So they actually had to go out and discuss it. He made them, consider it. And they determined that it was appropriate, guardianship was still appropriate. But again, what that did is wasn't just this amorphous concept of, oh, supported decision-making, people are self-determined and we're doing person-centered planning and we're going to help them, live the best life they can. It's now a thing, and there's some power in, air quote thing that people can look at, and there are standards and definitions around that are helping us become more sophisticated in how we approach supporting people with disabilities through our systems. Because before that, have you considered it? Oh yeah, we consider supported decision making, the concept. We'll ask them. This is a little bit more tangible, and that can be an effective thing if you're trying to improve bureaucracies and systems and change the way people with disabilities are viewed in our society.
Well, thank you so much. If you could stop sharing your screen just for a moment
Sure.
here, and we're going to flip back over to Melissa, who will just do some quick ending stuff. I'm also going to get the feedback form there, but George, if you could just hang on, we'll see if there's a couple other questions after we release everybody who might want to go. But
so how I'm trying to figure out how I stop sharing here. I click on.
I think I just.
Oh, did you?
Yeah,
just
I
move
think
it?
somebody
Oh,
else.
yeah,
Can,
just
oh, here.
you,
There it is. Okay. I stopped sharing. I saw the button, so I'm back.
Good.
Yep.
Okay. All right. I'm just gonna wrap it up here. Oh, I just did something.
What'd you do?
Okay. Well, the sharing button's right over what I have to share. Okay. Just to wrap everything up, so like Tim said, he's going to send out a survey if everyone can just fill that out to help us improve any future trainings. And we'd love to hear some feedback. All of the presentations are available on YouTube under Transition Talks Tuesdays. And then this presentation and resources and all of our previous presentations and resources are on the Transition Tuesdays website, which is a part of the Children and Youth with Special Healthcare Needs website. Just one final reminder, our next training, our last training is May 25th, and it's just a wrap up a presentation called What is After High School by an organization called Family Voices. And it'll just be a great wrap up to kind of a overview of a lot of the things that we've talked about these last, I don't know, how many have we had? 7 or 8?
This is 7 now. Yeah.
Wow.
Number 8 next week.
Yep, 7. Our last 7 trainings. All right.
All right, so I would like to just encourage everybody before they, if they do go off, please do go ahead. The feedback form is in the chat. And so please just click that. You'll go to the feedback form, take a couple minutes, and they can go ahead and sign out. We do have another question for George in the chat box that we'll continue with here. So you are free to go. So just anybody, if you want to stay for more questions, that's fine. We're not going to go too much longer. But the question is, I'm a little confused. Is supported decision-making handled centrally and legally, or is it something you do at individual service locations? So can you just really briefly, talk about the decisions made with the family that then get applied to the different locations and organizations?
Yeah. There is no central approach to supported decision-making. If you get the form, which, BPD has, that I was going through the chat, you had the right link. You can print out that form, you can handwrite it. One of the reasons, the form serves a couple of purposes. One is it provides a framework for the person with a disability to work with the supporter to outline what it is that they're asking for and the help that they need. And is it going to be in the area? And I'll use financial. They need to get a loan for a car. Maybe they have a job, but they get confused with some of the terms, and they want somebody to be able to be there with them, and that the entity like the credit union or the bank understands that this person can be there. Because that's the other reason for the form, is that if they have if the organization has a copy on it of that form, and they give you the loan based on your decision. I'm the person with the disability. I came in with Tim, and Tim explained it to me, and I made the decision to buy a car. And now all of a sudden it wasn't really a great decision. I cannot go in and say, well, you should have known that I had a disability and you shouldn't have given me that loan. You should have known better. And it's basically, there's some liability protections for the bank saying, we relied on this. There are liability protections within the law that says if we, in good faith, take this, that you're making the decision, you can't then turn around and say, oh, my disability, lets me to do a do-over at the organization's detriment, because that was part of it. It's like doctors also, if somebody's sitting in and I'm making a decision and it's like, whoa, maybe I shouldn't have, it's like the doctor said, I sat there with George and Tim explained it. He helped them understand what IV was. And we redid the jargon. They actually left and went to the cafeteria, had a cup of coffee to talk about it before they decided what to do. They came back. Tim sat through the whole presentation. George signed a release for Tim to sit through this meeting about what it is that we were talking about. But the supported decision-making, you can target it to a particular realm. Maybe there's somebody that you want help with medical. We see this for elderly as well, for elderly. A daughter may go in with her mother to start getting, help with, because, these appointments have to go pretty quick and you have to move through it, and a lot can be thrown at you, and daughter's taking notes. And so it also, part of my practice is elder law, and we see this as a way of transitioning people from more independence to actually maybe even more dependence and more interdependence, because maybe mom and dad aren't ready to sign a power of attorney, but they do need help when they go to the bank for some things. And you can create an outline, and then you have the discussion with your supporter about what's the scope of what you're asking them to do. It doesn't give people free rein to just go through your whole life, because you'd have to work with the organization. The clinic or the bank may say, yeah, we can share information with Tim, but you need to sign our release that we have that on file that Tim can get there. So we don't have you, 3 months later saying, why did you give Tim my financial information? It's like, well, we talked about it. You have your supported decision-making on file. He was helping you. You signed a release that allowed him to get the records. Because again, think about it. If I'm a person who can't drive and I don't have a computer, but I need to look at my financial records. I can have Tim go get them, and then he can come and we can talk about, oh, do I have enough money in my account to buy a car? What are the payments? How is this going to impact my budget? So it's a way of having a framework around a particular decision, and people can customize and craft them as they see fit. And we're going to be, I think, learning by experience over the years. So hopefully that helps.
I think we lost Tim.
Okay.
No.
Yep. Switched over to somebody to be.
Yeah, I think it was me.
Yep. Went to Melissa. Pressure's on you.
All
You
right.
had another question,
With the
Teresa?
timing, 'cause I have a question. Where, as you were just talking about that, I just wonder, where is I think about like going to an appointment with my parents or even like my child when they become an adult, if there's like something major and maybe they just want some support, or going with a friend, or I guess I really believe in supported decision making, but then I also am in my head kind of trying to understand where you need to have like this formal supported decision making forms filled out versus just being a support that like I would provide to.
I mean, it does presuppose that there is some kind of functional impairment. Okay. And that functional impairment could be age related. Hearing loss, not being able to, you have an elderly parent, they can't hear so well. That's a disability. That's a functional impairment. That, if they don't get the information right, can be a detrimental. And so what we're trying to do is set up a mechanism to that also pushes back on some of these systems so that they just don't push back and say, we don't do that here. It's like, no, we have, you have to let me in the door. You have to let my person in the door, and we're using this process to require you to do that. Okay. If you want to go to a car dealership with your sister who's really good at negotiating, you don't need a formal supported decision-making document. This is for those folks that, if you read the statute, it talks about a functional impairment. And that's the realm. But we all get this, help with decision-making. When I bought my first house, I got supported decision-making information from my parents. They bought houses before. They went with me to tour the houses, and my mom looked at things that I would never have looked at as a 20-something. What do I care that the cupboard doors they bang into each other when they open? I'll open one at a time, and things like that. It's not necessarily required. It's for those people who they need some. Most people would recognize they need some support, but we were running into, like I said, the difficulties with these big systems. How do I go up against a banking system to say that I can be in a room with my son just because? I mean, I know I can, and I can file court papers and I can sue them, but I would argue not everybody has that capability, right? And we run into this. It's like, it's discretion is a better part of valor. It's like, yeah, you have every right to do it, but do you have the financial resources and the time to basically sue Wells Fargo to do what they're supposed to do under the law? Probably not.
So
it's more for people who have a functional impairment. It doesn't mean necessarily exclusively intellectual. It could be vision. Read the fine print in the release form, or the drug interactions, or the potential complications. Somebody may want to have somebody along with that, and this puts systems and bureaucracies on notice that you just can't disregard somebody. I had a case, right, a situation where a guy came into my office, He was in a power chair. He came, it was Mike and Bob. Mike was in the power chair. Bob was his friend. Mike had a cerebral palsy. It affected his speech. He was fully capable in processing information, but he got so tired of going into the credit union or to the healthcare provider. And Bob was there to help him. And this was before supported decision making. And because the disability impacted his speech, you know how people make that, they can kind of talking. I'm just saying it was slow. So then it's hard. His friend Bob had an ear for it because they talked all the time. He could help move things along a little bit, but people would inevitably, and I've run into this with interpreters in court, they'll start to talk to the person or the interpreter. And he found that so disrespectful. It just it made him, just galled him that here he was processing, but people, because he couldn't speak clearly and enunciate quickly, like maybe you and I can, that they started making the back of the brain implicit bias started coming in. And it's just easier. I'm going to talk. And he found that so disrespectful. He said, well, what can I do? And I said, well, you can do power of attorney, but Bob didn't want power of attorney because he didn't want to have to get access to his friends' bank accounts. And he didn't want to give Bob power of attorney. He just wanted a way to say, you can't use your bureaucracy and your system to keep my friend out of this room when I want him there, because we were finding that was the case. So, but if you're going to a car dealership with your sister and she's a better negotiator than you are, and you're better at something else and you go with her to that, that's not what this is for. It's for these ends of the spectrum. But the concept is we all get support in making decisions because we can't know cars, houses, talking to somebody about a job opportunity. We do it all the time. But this process helps someone with a disability keep it framed about what it is. And then, as a supporter, what you're being asked to do. Your mom may say, I just need you for this, this series of appointments because they found a lump and I'm scared and I don't hear so good. And, I want you there and I don't want to have any trouble with the bank, with the clinic or the specialist or the hospital administrator or the billing office. I mean, I can just go on and on because you get this in the system, then you don't have to redo this every time, because that's what they do with these forms. They scan them and then you go to a different, and it's like, look up the release. I'm in the system.
So we have time we don't have time for any more questions, but Teresa's been very patient. So Teresa, we're going to take your question, then I'm going to have to call an end to the night.
You're muted.
It's no problem. I think I got it. So you guys can go ahead.
Okay.
Well,
I think it's been super helpful though.
I certainly hope it has. I will take questions from people that participated in this. All I ask is that you can give me some context that, hi, I'm Teresa. I was in your listening to your presentation. I have one other question. I've said this dozens of times that I will answer questions. I won't get into, specific legal advice, but if there's something else that you want to ask me about, I'm passionate about this work. It matters. I want our communities better. I want more parents doing more creative things and innovative things for their loved one, because the better our communities get, the better it is selfishly for my son. So I'm happy to answer any additional questions.
One of the things that you can do is I put my email into the chat box. So if you email me and say, hey, I was at the presentation, I have a question for George, then I can hook the two of you up. That's not a problem, because if you don't do that, then people email me and say, I want to talk to George. And then I have to go, who are you? And then I have to figure out that context. Signa, did you have something quick that maybe you wanted to ask George before we sign off here?
Sorry. I mean, I wanted to talk to George because I represent the county in guardianship and protected placement cases. And I was hoping to get more information about the work group that you are affiliated with, perhaps offline.
Sure.
Okay, so Signy can connect with me, then I will connect her with you. How's that, George?
That sounds good.
Okay.
Thanks, Tim.
Absolutely. Okay. Everybody have a great night. I'm going to stop the recording and I'm going to go relax. And I hope y'all, well, I hope y'all don't have a recording stop, but go relax for the rest of the night. Thank you so much for being here. George, thank you.
That was
Well-
great, George. Thank you so much.
Yes. And exactly what I wanted. Thank you, sir.
Okay, good. Thank you.
Have a great night.
Thank
Bye.
you. Bye.